right, let's start in general about just a couple of things, and then we'll kind of get into the specific requests, all right? But in generally, when we start doing estate planning, Medicaid planning, thinking about what we need, what documents are necessary, we need to keep in mind that we need to think about what documents in case we become injured, disabled, or incapacitated while we're alive. And we need to think about what do we need to do and what do we need to have in place to make sure our wishes are accomplished when we die. So it's a two-pronged test. You know, can somebody help me if I become disabled, if I get Alzheimer's, Parkinson's, ALS, Huntington's disease, if I get injured in a car wreck, who's gonna help take care of me? How are they gonna take care of me? And then what happens when I die? Who's gonna get my property? How do they get my property? Those are both kind of the viewpoints we want to look at when we start talking about estate planning, Medicaid planning, trust, wills, and advanced directives, all right? So with that mindset is the mindset we need to always have. And so let's go through first just a set of documents that we want you to just have a basic understanding of. So let's go to the power of attorney slide. It should be, keep going, next. All right, so a power of attorney we hear about all the time. And if you're in a hospital, you're at a nursing home, you're talking to a social worker, often they'll tell you, just print something off the internet and sign it. This is bad advice. Okay, bad advice. Your power of attorney is a document that should require some attention. You need to think about how you want your power of attorney drafted. You need to think about who's going to be your agent. You need to think about when it becomes effective. And you need to think about what powers do you want your agent to have, right? It is a very important document, and just signing something that's a form is not sufficient planning. Okay, so our agents can be our spouse, it can be our children, we can have co-agents, and so we need to give that some thought. If we name our spouse as our agent, what happens if they become disabled or if they die? Should we have alternate agents? So we need to give that some thought. What happens if we don't really have any children close by? Do we want to get a bank involved? Do we want to get a care management team involved in taking care and helping us make decisions? So those are all things we need to give some consideration to. So those are all things that are available to us. And then our power of attorney can be general or it can be special. It can be just a general power of attorney that says, I name you as my agent and I give you this list of powers, sign. You initial the right powers, and then that person has a fiduciary duty to manage your financial assets that are listed and covered by that power of attorney for your benefit. Right, it's a fiduciary duty. Now, they are your agent and they have to manage your assets only for you. They cannot make gifts. They cannot do ladybird deeds. They cannot set up trusts. They cannot change beneficiaries on bank accounts. They cannot do that kind of planning just because you signed a power of attorney. You have to authorize additional powers in your power of attorney, and you have to specifically list them out on what you authorize your agent to do if you want them to be able to do more than just the basics. Okay? If you don't enumerate them inside your power of attorney, your agent can only do the basics. And if they do more than the basics, they could get arrested and they could get sued because they're breaching fiduciary duties. This came up in our office just this week. We had some clients come in, they had qualified for Medicaid, mom died, and now Medicaid is wanting to take the home, have it sold, and be reimbursed. They did a ladybird deed. Mom signed a ladybird, mom did not sign a ladybird deed. They signed a ladybird deed using a power of attorney. That power of attorney did not authorize them to sign a ladybird deed. So that ladybird deed is not a valid deed. Right, so they've come in to see us. They were trying to sell the house. The title company won't let them sell the house. The title company reported the deed being not a valid deed to Medicaid, and now they find themselves in a problem. Right? So you need to be careful and give some thought and attention to your statutory durable power of attorney, all right? Who's gonna be your agents? Do you want to give them extra power? Do you want them to be able to sign a ladybird deed? Do you want them to be able to give the money out of your estate in case they want to apply for Medicaid? If you want them to be able to do that, you've got to give them the power specifically. Now, if you give them those kinds of powers, however, you also give them the power to do that, which means they can take the money and disappear. So you need to be careful about that. Give that some serious consideration. Maybe you want to name 2 children as co-agents that have to agree on what actions they take. So maybe that's a little safeguards and keeps one kid from just helping themselves to the money under the gifting authorization. All right, so be very careful about that. The power of attorney can be effective immediately. The minute you sign it, they have the ability to use it. Or it can be made effective on subsequent incapacity or disability. So it's not effective unless they get a doctor's letter. But if you make it that way, it's burdensome for them to use. They have to get regular and routine letters from the doctor saying you're disabled or incapacitated every time they want to use it. Otherwise, the bank, the investment institution, or other places are not comfortable accepting it unless they verify regularly that you continue to be incapacitated or disabled. So maybe we want them to go through that trouble, but we need to make sure we think about that. All right? Next slide. Medical power of attorney, we should all know about. And we all, if we have primary care provider, every time we go in to see our primary care provider, they have a sign on the tablet, another so-called version of medical power of attorney, every time. All right, that medical power of attorney is specific to that location. There is no database where it will show up everywhere. So you need a medical power of attorney that's general in nature that can be used wherever you might end up at. Because you might end up at St. David's, right? But you might end up at Ascension. You might end up in a different city altogether. All right, so you need a general power of attorney that you can use wherever you're at. You also need to be careful to understand that this only becomes effective when a doctor says in writing you are incapacitated. Then your agent can make decisions for you. What happens all too often is a daughter or a well-meaning son is taking mom to the doctor and they're doing all the talking and they're doing all the decision-making just because the adult is an elderly person. No, that elderly person should be making their own medical decisions, not their child, unless they're truly incapacitated. Both power of attorneys, your agent is your helper, not your boss. Okay, your agent is your helper, not your boss. The only way they're your boss is if they get a guardianship. Then they take over like a parent would. But otherwise, you should be in charge. If you're helping your mom or dad or somebody else under a medical power of attorney, you should be deferring to them, letting them make the decisions. You shouldn't be making the decisions unless it's in writing they're incapacitated. Next slide.
Is that true with spouses?
True with spouses, yes. It's true with spouses too, absolutely. You are your husband's helper. Your husband is your helper, not your boss. Okay, that's exactly right, 100%. A directive to physicians is a document where we put in writing what our wishes are if we're on life-sustaining treatment. All right, this is a very important document because this tells our medical power of attorney agent, this tells our doctors, this tells our family members what our desires and wishes are. And our agent and our family and our doctors are required by law to follow our wishes if they know our wishes. If they don't know our wishes, then they are required to do what they believe is in our best interest. And we don't want them deciding what's in our best interest. We want them to follow our wishes. So we need to put it in writing so they know what our wishes are. right? Do we want to be on life-sustaining treatment? Do we want to be on a ventilator? Do we want to have a feeding tube? Do we want to be on an IV if that's what's keeping us alive? If we're otherwise terminal and we're not otherwise going to survive, do we want them to keep us alive? Yes or no? And we can say this in this document. And it can go either direction. 90% of the time when we draft this, we're saying, don't keep me alive. But every once in a while, I have someone that says, oh no, I want you to keep me alive, no matter what. And then they can say that in this document, right? It can go either direction. Next slide. You can do an out-of-hospital DNR. You should not do an out-of-hospital DNR. You can do one, but you should not do one unless you are ready to die. Like now. You're ready to die now. Because this document says, if I fall over, I quit breathing, or my heart quits beating, I do not want you to help me. And that means I'm ready to die, okay? So do not do this unless you're truly ready to die. This works well for people who are bedridden at a nursing home, at an assisted living, maybe in a memory care, maybe bedridden at home, and they're ready, all right? It has to be signed by the patient and by the doctor because it's an actual physician's order. It's not just my wishes, it's an actual doctor's order that you consent to. So it has to be signed by both patient and doctor, and it says, do not revive me if I fall over, all right? It has to be conspicuous and it has to have an ID with it. So if your mom's at home, bedridden, and it's time for her to go, you would probably put this on the refrigerator, or even better yet, post it on the wall next to her bed, along with a copy of her ID. That's what you would do. That way, if life-sustaining people show up, the ambulance in particular, they won't do anything.
What's the difference between that and the ones that we present, the DNRs that they think about?
Well, a DNR is not a DNR unless it meets a specific form. It's signed by the patient and it's signed by the doctor. Just because it says DNR on it and it's printed from the web, it's not a valid document. It has to meet a Texas specific format, and it has to be signed by the doctor and it has to be signed by the patient. Otherwise, it's not a DNR. Now, some people confuse the living will or the directive to physician as a DNR. Okay, some people get those confused. Those are two different things. The directive to physician, which is also called a living will, is just my wishes of how I want you to treat me and take care of me if I'm on life-sustaining treatment. That's the living will. It is different than a DNR, which says if I quit breathing or if my heart stops beating, how I want you to treat me, right? And the DNR has to be signed by a doctor. Okay, next slide.
One quick one. So,
Yeah.
in our case, we have as a caretaker, still a little confused as to how we deal with it. Just call the ambulance? Do we call and go?
Well, you would call the ambulance, I think. You would call them and say, listen, my mom, I think, is not breathing anymore, but she has a DNR signed by her doctor. But I'd like for you to send someone out because you're gonna need help if she passes away. Right, so but I would call them and not say, hey, rush over, mom, stop breathing, I need help.
Right.
All right, come as fast as you can. You would call and say, mom has stopped breathing, but she has a signed DNR by her and her doctor. We have it here. So I feel like she's probably going to pass, but I'd like you to send someone over. That's how you handle it.
And is a copy of that signed document sufficient?
I think so, yes. I don't know of anything that says you have to have the immediate original.
Yeah, you can make copies of them, so I understand it. So, who makes the determination? So we have asked for them for our respite program, but I'm wondering if we should really even inquire about that because then it's a burden on us.
You shouldn't, as the respite program, you should not be worried about the DNR.
Okay.
At all. If they come to you and say, we have a DNR, and we want you guys to know about it, I'd almost push back a little bit and say, listen, if they fall over, on our trip to the horse place, we're gonna call the ambulance, you want to avoid liability issues.
Okay, and that's what I figured too, because not all of them are filled out correctly, because it
Yeah.
is, you have to have the physician sign in two places, and then you have to have, the witnesses, or, and
It
it's like,
has to be done specifically right. It has to be signed by the doctor, and so a lot of times people just print something off the internet and call it a DNR. You don't want to be accepting that.
right, okay, and that's what I figured. So if, in the case that somebody had one, just for my own knowledge, they had one and it wasn't filled out correctly, EMS gets here, who makes a determination and say, well, this isn't filled out correctly, so
EMS does.
they do, so, okay,
You defer to EMS. You do not get involved in that. at
okay, I
all.
figured, okay.
Okay, and EMS is going to work on it.
Mhm.
Okay, unless it's abundantly clear that it's right and there's an ID, when EMS shows up, they're gonna go to work, right? So you stay out of that. You call the ambulance, you let EMS worry about it, and you stay out.
Thank you for that.
Okay, absolutely. Okay. Next slide. Declaration or designation of guardian. This is a document that's not really an advanced directive, but it's something we like to use in our estate planning and be aware of. You right now, while you're healthy, can designate in writing who you would want to be your guardian if at some point the court was appointing a guardian over you. So on a power of attorney, your agent is not your boss. We talked about that. But if somebody goes and becomes your guardian, they do become your boss. So you get to select now who you would want that to be. So if you're concerned down the road about who might be your boss, meaning who gets to dictate where you live and what you eat and what you wear and what medical care you get to decide that person now while you're healthy.
You just used the word advanced directive. Is that one of these documents you just talked
The
about?
advanced directives are all the things dealing with medical care. So your healthcare power of attorney, your living
So
will.
it's just a generalized.
It's just a general term for your medical documents. Okay, sorry about that. Yeah, yeah, good question. All right. So this is a directive in the sense that you get to direct who gets to be your guardian. Right? And you should do that in any kind of second marriage. Right? Third marriage, fourth marriage, this document needs done. If you have children that don't get along, you need this document. Right? Children that don't get along, even children who get along, but they are both likely to dispute who should take care of you and make decisions, then you need this document. All right? This is a very important controlling document in those circumstances, because if the judge is appointing you a guardian, they're going to want to appoint somebody you want to be your guardian. That's gonna get the presumption, all right? Next slide,
Sorry, I'm not sure. how
just
she-
hit enter, I think. Yeah,
Space.
space or enter?
Oh, she's on the Zoom.
Or the arrow, if you can.
There we go.
Okay,
Okay.
great, all right. All right, next document to know about is you can determine who's in charge of your body and make sure that you get buried or cremated. And then placed in the location of your choice. And you can do that in writing and designate who's gonna do that for you. Traditional family, it's not such a big deal. Husband, wife with 2 or 3 children together who get along, this really isn't an issue. But it is an issue in a blended family, all right? Second marriage, third marriage, or again, children that don't get along, it is an issue. So you can decide who will be responsible for taking your body and making sure it gets disposed of like you want to be disposed of, right? So you want to be cremated, you want to be buried, you want to be buried, next to your previous spouse, your first husband or your first wife, or do you want to be buried next to your current spouse's previous spouse? You know, where do you want to be buried? You get to decide that by picking the right person now in writing, all right? And if you don't, if you have even stepchildren that don't get along with your wife or husband, or you have children that don't get along with your wife or husband, then you want to do this stuff. It'll avoid them from fighting and arguing about who gets the ashes. Where does dad get buried at? Where does mom get buried at? You just don't have to worry about that. And those things happen. I was at a probate hearing one time and I was probating the will for the wife. The stepchildren were at the hearing and all of a sudden, out of the blue, in the middle of the hearing, one of the stepchildren stands up and starts arguing to the judge, saying that my client is withholding ashes and won't share them, and wasn't supposed to cremate the body, and it just erupted into a huge deal. So this is a very important thing to think about, depending on your family dynamics, right? It can avoid those issues, so it's out there. Next slide. A ladybird deed. A ladybird deed is a type of document that we use sometimes in traditional estate planning, but we often use it if we're doing Medicaid planning. So if we're going to go into the nursing home, and we're gonna get Medicaid to pay for our care, then when we die, we don't want Medicaid to come back and make us sell our house and pay them back. And we can avoid that by making sure our house transfers automatically on death to somebody. And we can do that to somebody or to a trust. And we can do that by using a ladybird deed. And it's not considered a gift because I sign it today, but it doesn't become effective until I die. And I reserve the right to change my mind at any time. Okay, so it's a very powerful tool that's in our chest. Think about, how do we want to transfer real estate or houses?
May I ask if that's the same as a transfer on death deed?
So a transfer on death deed works the same. They're two different deeds. We at our office prefer the ladybird deed. The transfer on death deed cannot be changed or signed by a person with power of attorney, even if it authorizes it. And a transfer on death deed does not convey a warranty. And a transfer on death deed cannot be recorded after you die. So there are some disadvantages to a transfer on death deed if certain things happen. So we prefer the ladybird. But they are similar. They both transfer the house on the right circumstances when you die.
If it's in a trust?
So trust is different. Trust is, we'll get to that in just a minute. Okay?
Does this work with, personal residence as well as other real estate?
Yes, sir. Yes, sir. It can work with a personal home, it can work with a rental property, it can work with 15 acres or 180 acres. Absolutely does, for sure. Okay, but it is different than a transfer on death deed. Our office does not use transfer on death deeds except for limited circumstances. Because there are potential problems with transfer on death deeds. Right? Next slide. All right, let's talk about wills and trusts for a few minutes, because we had some requests about that. All right. When we want to transfer property when we die, the most basic, obvious way to do that is through a will. In a will, we draft the will and we say who gets our property when we die. I give everything to my wife. If my wife dies before me, I give everything to my 2 children. Or I give $100,000 to Baylor University, $100,000 to the University of Texas, $100,000 to a gift of time. I give everything else to my children. However we want to draft our will. I give my ranch in such and such county to my ex-wife, or I give my rental property to my current girlfriend. I can do whatever I want, as long as I'm mentally competent when I sign the will. All right, as long as I'm competent in my capacity, I can do whatever I want. Now, my will designate who gets property, how they get the property. It'll designate who the executor is. So that person's going to be in charge of my property when I die. And it can involve estate taxes and planning for estate taxes if I needed to. Now, next slide. The last will and testament has to go to probate. If you do not probate the last will and testament, it does not transfer property. I get people come in and see me all the time, and spouse, husband died 12 years ago. Did you probate the will? Why not? Because it says I get it. Well, the will does not by itself effectuate a transfer. The will has to go to probate. So a judge has to appoint the executor named in the will. The judge has to either set a bond or waive a bond if the will says waive a bond. And then the executor, once they're appointed, they have a duty to gather assets, pay debts, and then deliver the property according to the terms of the will. That's how that works, right? If that isn't probated, that will does not transfer property. And that could result in a very bad consequence. So we need to always be mindful. by the last will and testament, I need them and I want it to be controlling, I have to probate. Okay,
If you have the property labor deed, then does that mean it's outside of probate?
great question, yes. So the will and the probate only controls probate assets. So if I make an arrangement for an asset to transfer automatically when I die, then that asset will transfer automatically according to those arrangements, and the will not control it. So a ladybird deed would control that particular property and say what happens to it when I die, so the will would not control it. So I have to be careful, because I might do a ladybird deed that says, I give my house to my children when I die. I might get mad at my kids and then do a will that says, I give my house to my second wife. But the ladybird deed controls because it's specific to that property and it's outside of probate. So you gotta always be mindful of everything when you're doing your plan.
So that means you do not have to file the will at probate.
Well, not for the house. You might have to file it for other assets depending on how they're set up, but you don't have to for that house. That is correct. All right, next slide. So trust. A trust is a document that sets up kind of an alter ego for us. And it allows us to put our assets into the trust now. Now, right now I'm talking about a family living trust. There are lots of different kinds of trusts, okay, lots of trusts. But your most typical trust that you hear about and talk about is a family trust, a living trust, a revocable living trust. And that's what we're talking about right now, right? So I create my living trust for my wife and I, and it says, my wife and I are the trustees. That means we manage the trust. My wife and I are the beneficiaries of the trust. That means we manage the assets of the trust for ourselves. And it's revocable while we're both alive. That means we can do whatever we want with whatever that trust owns, as long as we're both alive, right? The assets are in the name of the trust, though. They're not in my name or my wife's name. They're in the Rainey family trust name at that point. But it's my alter ego. I can revoke it, I can change it, I can do whatever I want, as long as we're both alive, because it's revocable until we both die. Now, the nice thing about having the trust, if it owns my house, and it owns my second house, it owns whatever land I have, it owns my checking, savings, my Charles Schwab accounts, it owns my cars. When I die, my wife doesn't have to do anything specific to changing those items. They don't have to go to probate. They don't have to worry about a ladybird deed. Everything just stays the same as long as I have it remaining revocable when I die. She does nothing. She's the trustee of the trust. She managed the assets for herself. Nothing changes. Now, I could say when I die, my share, my half of the trust goes into an irrevocable trust for her benefit. So she could keep her half in a trust and do whatever she wants, no changes. But she might have to move my half into an irrevocable trust at that point. And then I could say in my irrevocable trust that these assets can be used for her benefit, for health, education, maintenance, support. But then when she dies, whatever's left over goes to my children, which might also be her children, but they might not be, right? I might have children from a previous marriage. And so I can then try to make sure there's something left over for my kids. My money can benefit her, and whatever's left over benefit my children. I can do it that way also. Those are two common ways to do that. But no probate's necessary, no court intervention is necessary. My wife is the trustee, she just follows the instructions. And then when she dies, my kids are co-trustees, they just take over and they follow the instructions. No probate is necessary. The instructions are sell the house, sell the cars, and then split the money equally. That's what ours says. All right. And it's that simple. All they got to do is have a death certificate to give to our banks. And we have some money at Charles Schwab. They give Charles Schwab the death certificate and their IDs. and boom, they're in charge. So that's how a trust works, right? So two different ways to do things, both can be very appropriate. A lot of it just depends on what you want to happen and how you want it to transfer when you die. A family trust while I'm alive that owns all my assets will have my spouse named as co-executor, and it will say, if I become disabled, she's now the only trustee. So she just takes over. If we both die, the children just take over as trustee. If we both are disabled and still alive, the children take over and have immediate access to the assets and manage it according to the instructions. So it's very flexible too.
Who's determining this?
We do have to get a doctor's letter for that. Yeah. Just get the doctor's letter for that. That's all that is. So that's where we're at on that. So that's kind of the differences between the trust planning and will-based planning. So sometimes people will have just bank accounts and a house and a pretty straightforward estate. And just checking, savings, one car and one house. And they're like, well, I don't really want to do a trust. Maybe we'll do a ladybird deed and beneficiary designations on the accounts. Even in that situation, if you have more than one child, I would recommend a limited trust for that. What happens as much in equal amount of times as it doesn't happen is that if 2 or 3 children get the house, whether it's through a will, from a trust, or from a ladybird deed, it doesn't matter. If it ends up in the 3 of their names outright, one of them's not gonna wanna agree to sell it. And one of them's gonna want to sell it. And then there's gonna be a lot of contention and problems. Right? But we can send that house to a limited trust that through the ladybird deed with instructions to sell this property, split the money equally, unless you agree to something different in writing. Right? And then that's what's gonna happen. And that just saves a lot of attorney's fees, heartache, hate, emotion, and expense by doing that. Right? So that's something to think about as well.
So, for bank accounts like Schwab.
Yeah.
As long as you have a secondary beneficiary, like my husband's my beneficiary, and then my kids are my beneficiary, or.
Yeah.
He's 50% and they're 25%.
Sure.
Then it's clean, it doesn't go through probate, correct?
Correct.
Okay.
That's a direct transfer on debt. So that those are not probate assets. Just need to be careful when you do that kind of planning, that there is still money to pay off your final debts and to help the estates. So sometimes what happens is mom dies and she left the accounts to 50-50 to the 2 kids. And one kid comes in to see me, she paid the funeral expenses out of her pocket. She can't get reimbursed because the sibling who inherited 50% of those monies ain't going to agree to pay out of their now money they got from mom for mom's funeral. All right, so you've got to think a little bit more advanced than just, oh, I put a beneficiary on here. You've got to think in terms of, well, have I arranged for the funeral and prepaid for it? What other expenses might happen and need to be paid for me when I die or right before I die? And how are we gonna pay for it? Okay, because a lot of times people just do planning like that. And then that really disadvantages one of the children. Okay. All right, next slide, next. All right, next, we kind of talked about this. All right, here's 4 different kinds of trusts that I just want you to be aware of. And these are trusts that we can set up in your will or trusts that we can set up in your family trust. Or sometimes we just set them up as standalone trusts, especially for number 1. So sometimes you have families that have children with special needs. They might be autistic, they may have cerebral palsy, they may have countless other issues, genetic disorders. And they are gonna get, or they may be getting Medicaid or SSI. Well, we don't want them to inherit money from you when you die. That's gonna kick them off those benefits, right? So we can set up a special needs trust, send money to the special needs trust. And then that money in that special needs trust can be used to supplement their life and still allow them to keep their benefits. All right, so it's very important to be aware. We can do a special kind of planning, where we say we want to have a probate when we die. We want our house, our car, our bank accounts, everything to be controlled by the will, and we want to go to probate. And then in that probate, we can stand up a special needs trust for our surviving spouse. So if I die, I send all of my half of the assets into the probate. And in my will, I say, I want all of my assets to go into a special needs trust for my wife. Then what that does is it stands up the trust in the probate process. It moves my assets into that trust. And then all of that money, assets that went into that trust are now shielded and protected in case my wife needs nursing home care later. They don't count for Medicaid qualification. They don't count for other creditor purposes. They're all shielded assets. So I can do that through, but I have to do it a very particular way. I have to do will-based planning. I have to probate the will, and I have to have all the assets go into a special needs trust that stands up and is created through the probate. But if I do that, I can shield all kinds of money and assets and have my spouse available for Medicaid to pay for their care and protect her from other creditors. It's a very powerful plan to me. Sometimes I have people come in, especially with second marriages, third marriages, kids that, worried that even though I'm a regular traditional family, if I die, maybe my wife will marry someone else. And then if she inherits everything, maybe she leaves everything to the new honey instead of to our children, right? So that's often a concern. It's also more of a concern on the blended family, right? I die, my wife may decide to leave everything to her kids, not my kids. And it could be because they become contentious with each other, but it could just be simply they drift apart. I'm gone. Every Christmas now, my kids aren't going to her house and they just drift apart. So she leaves everything to her kids who come over every Christmas and call her on the weekends. All right. So what we can do is a type of trust, like I mentioned earlier. I die, my share of the property goes into an irrevocable trust, can benefit my wife, but then what's left over goes to my kids. So we can do trusts like that. And then we can do trusts for our kids. So whatever money we want to go to our kids when both of us die, can go into a trust for our kids. Doesn't have to go outright to our kids. We can put it into a trust for our kids. And by doing that, we protect our kids from that money from a divorce, from creditors, mostly those two things. It protects if that kid were to get divorced or have creditor issues, that everything in that trust is protected, right? So it's a good way to do that. Now, I have a lot of people come in and say, just yesterday, how do I keep my wife's son or my son's wife from getting any of this money or benefited from this money? She is really rude and won't let us see our grandkids. Those types of things happen a lot. Well, then we start talking about a trust for the kids. Okay, next slide. All right, so let's talk just for a few minutes about Medicaid qualification. That was the next question. We'll spend about 10 minutes on this and then we'll be done for today. Okay. All right, next slide. All right, next. And one more. All right, so one more. Let's get through all this. Keep going. All right, so nursing homes can get paid for a couple different ways. We can pay for it if we have long-term care insurance. We can pay for nursing home care out of our pocket, just our savings, and use it each month. We might get our nursing home care paid for if we're a veteran and we're disabled 70% or more, then the VA will pay our nursing home care. We might be entitled to a little bit of the money from the VA to help pay for nursing home or home care if we meet certain requirements. Otherwise, we might try to start looking to see whether or not we could get Medicaid to pay for nursing home care for us or our spouse or our loved ones. More often than not, we start talking about Medicaid. How do we get Medicaid to pay for our nursing home care? be mindful that Medicaid only pays for nursing home care. It does not pay for, as Becky said earlier, memory care. It does not pay for assisted living. It only pays for skilled nursing home care. So be mindful of that. All too often, well, people come in and see us and mom's in a memory care unit. That's not, and they want Medicaid. That's not covered, right? Most memory cares are considered assisted living, not skilled care. There are nursing homes with skilled care facilities that have memory care wings. That would be covered. But the Delaney or all these other places, they are not covered. Right? So we start talking about how do we qualify? Well, these are the things they're going to look at. You got to have a limited income, limited resources, which are also called assets. You have to have a medical skilled care need. You have to be a US citizen or a qualified alien, and you have to be a resident of the state of Texas. Right? Resident of the state of Texas is easy. Either you live here and you have a homestead here or you don't. A US citizen or qualified alien, easy. Either you have a green card or you were born here and you have a birth certificate. That's easy. Medical necessity is harder. Okay, but our office doesn't get involved in that. That goes between the doctor, the nursing home, and the patient. But essentially, you've got to need more than just help going to the restroom or eating. You got to have some medical component to it, all right? And if you do, then you'll get medical necessity. Quick tip. If you have dementia, moderate to severe form of dementia, and you take a prescription, then you will meet medical necessity. So dementia, moderate to severe, it can be Alzheimer's, vascular dementia, Parkinson's related dementia, it doesn't matter. As long as you have moderate to severe and you take a prescription, any kind of prescription, then you will meet medical necessity.
Any kind of prescription, like pressure medicine?
Exactly. Blood pressure,
Okay.
yeah, for sure.
In our case, he doesn't mention those actually.
Right, so you don't take them, but if he has blood pressure, or if he has some other prescription, a blood thinner, host of prescriptions that people take when they get old, any prescription, okay? Yeah, then they'll meet medical necessity. All right, so let's now talk about income and resources for a few minutes. Next slide. All right, so income. When we go to the nursing home, they're gonna look at the income of the person going into the nursing home. All right, so if it's a single person, that's pretty easy. They're gonna look at the person who's that single person went in the nursing home, what's their income? But if it's a married couple, they're only gonna look at the spouse's income that goes into the nursing home, right? So husband and wife, husband goes to the nursing home, they're looking at the husband's income, right? And they look at the gross income, not the net. So the amount placed into the checking account by direct deposit is a net amount. They're gonna look at the gross amount. They're gonna look at the amount before taxes are withheld, before Medicare Part B and Medicare Part D are withheld. If you have a pension, they're gonna look at the gross amount before taxes and before any health insurance premiums are withheld. So the gross amount. If the total income is $2,901 or less, then you're income qualified. If the total income is $2,905, then you are not income qualified. That's a monthly number, yes. But you can use a qualified income trust, QIT, if your monthly gross income is more than $2,901. So if you're not income qualified, you could still get income qualified by using a qualified income trust. And this is just a special trust that you get a professional like us to draft for you. Then you take that and you open up a new checking account in the name of the trust. And then the income goes through the QIT account each month and then goes to the nursing home as a copay. And as long as you do that way, then you're okay if your income is more than $2,901. But now that QIT trust is sometimes called a Miller trust. Only relates to income. You cannot put assets in this trust and qualify. It only deals with your income and only if your income is greater than the limit, which is $2,901. Right? Now, if you have a spouse at home, the wife stays at home and her income is less than about $3,900 a month, she might be able to keep some of her husband's income in the nursing home. Because Medicaid says we want the spouse at home to make $3,900 a month. So if her social security is only $2,500, she would get to keep enough of her husband's income in the nursing home to get her up to $3,900. Right, but once she gets to $3,900, it stops. The rest of his income goes as a copay to the nursing. Did I explain that well? Everybody kind of follow? All right, next slide. All right, so now for assets, what they do is they look at your assets on the first day of the month that you go into the nursing home. So today's like the 22nd? All right, so if I went into the nursing home today on May 22nd, they're gonna look at my assets and my wife's assets as of May 1st. May 1st. They will look at all of our assets, mine and my wife's assets. And it does not matter whose name it's in, and it does not matter whether it's community property or separate property. They're gonna look at all of our assets. Okay? Now, once they look at all our assets, they're gonna set aside some of them and they're not gonna count them. And those assets are non-countable resources or exempt resources. And we'll get in more detail to that. But the countable assets, after they set aside the non-countable ones, they look at a single person and they can only have $2,000 in countable assets. So they set aside the non-countable assets, and then the single person can have 200,000 of countable assets. If you're married and both husband and wife go to the nursing home, then there's a $3,000 limit. They can only have 3,000 between the two of them. If they're married, one goes in, one stays out, which is kind of the hypothetical we were talking about so far, then it's a little bit more complicated. They have a kind of a moving scale type thing, where if your countable assets are less than $31,584, then you don't have to do anything. So if you're married, you set aside the non-countable assets, and what's left is less than 31,000, you're qualified. If it's more than $31,584, then what you have to do is do what we call a spend down. You have to spend up some money. And you have to spend 1/2 of your countable assets until you have to spend up 1/2 or more. If you have to spend, because you can't have more than 157,290. So if you have $500,000 in countable assets, you would have to spend up more than 1/2 to get below 157,290. Right? But if you only had $100,000 in assets, then you would have to spend up half, 50,000. And you get to keep $50,000. Right? That makes sense? Okay.
Medicaid, if you spend down immediately before your application,
You don't, so the spin down, if you do want, ideally, you're not gonna do your spin down until after you go into the nursing home,
oh,
if you're married.
okay, thank you.
Now, that's immediate planning. Right now, I need Medicaid. You can do spin down sooner. You can do what we call 5-year planning. Try to get assets out of your name now so that they don't count in 5 years from now. So there are some things you can do like that. All right, okay,
Thank you.
all right. Okay, next slide. So some resources and assets that don't count. If you're single, you can have a house up to $730,000 in equity. If you're single. Now, in Georgetown, you don't, a $730,000 home is just your everyday home nowadays. It used to be 10 years ago, a very big fancy home in Georgetown. But now it's your pretty close to everyday home. You can get a nice home for 400-500, but you're not getting a giant mansion for 730 like you used to, right? Now, if you're married, it doesn't matter. You can have an unlimited value of a house. You can own the King Ranch with all of its, apartments, guest homes, corrals, barns, giant mansion, all of that, and it would not count if you're married. But if you're single, you have a limit, right? Burial spaces don't count for qualifying purposes. An irrevocable prepaid burial contract does not count. So if you prepay for your funeral and you spend $15,000 on it, and it's irrevocable, it doesn't count as an asset. One car of any value doesn't count. I worked with a family here in Georgetown not too long ago, and their son kept wanting them to buy a $267,000 Lamborghini with their cash. And we had to talk him down over that. And he's right. You can own that, and it doesn't count, but that still isn't a good idea, right? On the other hand, I had a lady who went several years ago, went and bought $100,000 Cadillac. And this is several years ago before all the prices went up. And she'd always wanted a Cadillac, and her husband's going in the nursing home, and she had cash we needed to spend down. She came back to my office 2 weeks later and pulled up in this Cadillac Escalade long. What did you do? Okay, but that doesn't count as an asset. Household goods don't count, personal effects don't count unless they're collectible items, right? Your everyday stuff doesn't count. But if you have fancy, really expensive antique furniture, or if you have a fancy guitar collection, or special coins, those things might count. Or what?
Artwork.
Oh, yeah, fancy artwork, like a Monet or something, that might count, right? Okay, next slide. All right, go back to the slide before that. I don't have, just press the up arrow. There you go. I don't have on there, some other things that don't count would be a college, certain types of college savings accounts don't count. As long as they already exist. Or you could start one for a minor under 21. So for a child under 21, so a grandchild or a great grandchild, grandmother going into the nursing home, she could create special kinds of accounts that are for minors. And those would not count, and it would not be a gift. And then family businesses. If we have a business and it supports me, and that's how I make my money, I can exempt that business and all of its assets. They won't count. An example would be, we had a husband and wife that owned a flower shop together. Husband went to the nursing home. We were able to exempt the flower shop. It owned like 7 vans, the operating account, all of the fixtures inside the shop, all the flowers, all of that was exempted and didn't count for qualification.
Basically, your bank accounts are the first and primary thing to look at, and then if they're over, then you stop. If they're under, then you start looking at these things. In terms of,
No, I think the way you do it is you look at an asset sheet of everything.
Yeah.
And then you say, okay, what can we not count? And then you take out the things that don't count. And then whatever's left over, you add it up to see where you're at.
Would rental properties count as a business?
Maybe. The answer is maybe. Sometimes yes, sometimes no. Yep. Okay. It kind of depends on how they're set up and how you're using them. But I would say more often than not, we're successful in counting them as a business, but not 100% of the time. You have something?
I was just gonna say, it depends on how the income is reported from the rental business, and then it also depends how hands-on the owner is, like if the owner actually goes and makes repairs, checks in on the tenants versus having some sort of management company that does everything for you. The more hands-on, the better.
Yeah. Just kind of varies. So, yep. Also last, IRAs, if you're 73 and older, don't count as an asset. A 401k or a 403b does count as an asset, but we can usually roll those over into an IRA. But remember, you have to be 73 or older. If you're younger, we can still get it exempted and not counted as an asset. We just worked with a lady who was like 66 in a nursing home with Alzheimer's. And so we were able to move that into a special kind of annuity IRA and exempt it. All right. Another family we worked with, the single person, lives out in the country, has a house, nice, with some land. But it was far enough out in the country that it wasn't quite 700,000. He had a $750,000 IRA. We exempted both of those. And those will go to his kids, and Medicaid's paying for his nursing. So those are things that we need to look at. All right, next slide. One thing that's also out there to be aware of, if the income for husband, if you have, it only works for a married couple, but if you have a husband and wife and their joint income is less than the $3,900 I told you about earlier, we can keep extra assets over and above the 157,940 we talked about earlier. But we have to have husband and wife have low income. Then what Medicaid will let us keep extra assets so that if we were to invest those assets into a CD, we could earn money that would get us up to the 3,900 a month. So that's something that's out there that we've been able to take advantage of as well. Next slide. All right, it's the same thing. Okay, I think that's really it for today. Other questions? No? Okay,
My husband has early onset Alzheimer's. Anyway, the car he bought it. It's in his name only, but I'm the beneficiary of it upon death. I mean, when we did whatever, registered it here,
Yeah,
when
yeah.
we moved here.
Yeah.
I get it
Okay.
upon death. But if I wanna sell it and I have a durable power of attorney, I can't.
you can. Now, technically, if you sold that car, that money has to come into his account or y'all's joint checking account. Yeah,
That's okay.
Yeah. as long as you did that.
So there's no reason that I should buy it or sell it and get something else in my name.
That just depends on your circumstances. You have a second car or a different car? What's the only car?
It's the second car, we can drive.
No, if you like the car and you have one car, then no, I think you're fine as it is. When it dies, it comes to you automatically, yeah. But you could, but you don't have.
If you do not have a trusted person or the executor of the will, or as the, what is it, the alternate trustee,
Yeah,
who do you turn to if you don't have, all your friends are older than you or that?
well, sometimes in those cases, we start saying, well, would it make sense to look at a trust company? Like, Extraco Bank and Trust or Cadence Bank and Trust. In those situations, that's what we want to take a look at. Would it make sense to just get them involved at that point, or professional? There's what we call professional guardians, but they also will serve as professional executors. It might make sense to get somebody like that involved.
But can you make arrangements so that the trust company is put into the trust or the will,
Well, you absolutely.
so that
need-
they will be, being paid in the provisions you make in the trust or the will?
Absolutely, you need to do it that way. You need to in advance get them placed in the will or in the trust. You need to have a conversation with them so they know about it and have a copy of it. And then, yes, they do get paid.
Well, how do you find these places?
Well, if you're working with our office, we know several places that we could recommend, and then you would just go talk to
Okay.
them.
I don't know if this is the appropriate question or not, but so you're a person and you're realizing you have none of this and you need to come to you or a different firm with that. Is there a consultation and how does it work exactly to get the call?
Yeah, so like if you come to our office, we charge a consult fee. If you then pay us to do additional work, we credit that consult fee. If you don't, you just come in and visit us for an hour or so and leave. We try to go through stuff like we do here, and then you leave with some good information. But if you decide to do work, then we'll kind of, and we would just go over your assets, what you have, what you want to happen, your spouse, if they can participate. If they can't, then we'll address those issues and then figure out a charge based on what you need to do.
Hearing that a lot of nursing homes, particularly around here, really don't want to take Medicaid patients. There's a shortage of those beds. And they're not particularly good.
Well, I've not found that really exact to be 100% accurate. There are a couple, so the newest places, I think that's true. So when you have a place that's new within the last 2, 3, 4 years, they have a high demand for their facility because it's brand new, it's nice. And everybody wants to put their loved one in a nice place, you know, as opposed to a place like this that's older but kept up, right? Those places tend to reserve just a limited number of Medicaid beds and you have to get on a waiting list. But other than those places, it's not hard. Almost all the other nursing homes, it's not hard to get Medicaid bed at all. Now there is some rumors that you don't get the same kind of care, but legally you're required to get the same care from a Medicaid bed as you do from a private pay bed. The legal requirements are the same. So if you felt like that was the case, you would want to call and file a complaint with the state and they would investigate. And by the same nature, the oldest nursing homes who aren't as nice as are the easiest to get into because nobody wants to be they all want to be in the brand new place, right? So that's kind of just the dynamics of how that works.
Let's say that someone becomes,
Ah.
say partway through, and then the caretaker that does the leave or whoever, you know, is the recipient of that, they pass away.
Yeah, it's hard to do that on the Lady Bird deed. That's another reason why we like to have a limited trust, because in a trust, you send it to the trust and then you can have all kinds of options.
Fair enough.
You can do that on transfer of death deed easier, but
But
no, in transfer of death deed, again, we don't like. Thank you guys for having us out. Yeah,
Awesome.
thank
Thank
you
you.
on the video, people.
Thank you.
Thank you. Thank you.
Becky, this is Sandy Lowe. Can you hear me?
Yes, Becky stepped out,
Oh,
but
okay.
if you have any questions for her, I can definitely take them down.
Well, I just wanted to know if we could get a copy of the slides or
Of
maybe,
course.
okay.
Yes, I will.
And a transcript,
You just take it.
I don't know about a transcript.
Okay, well, just a
Sure,
copy
we'll
of the
fix it
slides
up,
would,
but at least the slides, I'll make sure.
okay. Thank you very much.
Of course, thank you.
Yeah. You can call Bob or about this.
That is just have